Namaste. Welcome to my channel, the UPSC Game. Hi aspirants. 2 days back, there were many DMs in my Instagram account requesting me to do a series for UPSC CAPF, which was dated on August 3rd. There were some messages regarding how to do the PYQs of CAPF and where to do, what are the sources. So I have come with the new series. Here we shall discuss the UPSC CAPF PYQs. Today we are going to do UPSC CAPF Polity PYQs of 2024. Okay. In 2024, under Polity section, there were 11 questions from Polity, which we are going to discuss in this video, right? First question was, who among the following presidents of India sent back the Post Office Amendment Bill 1986 for the reconsideration of the Parliament? You will not find such information in the Lakshmikant. Most probably, right? That is the reason you have to do PYQs, where such important key terms are repeated, right? With respect to the answer, that is Gianni Zail Singh. He used the pocket veto to prevent the Indian Post Office Amendment Bill in 1986 from becoming law. Then this is about the veto powers of the president. So we have to go deep into the basic of the veto power of the president, right? A bill passed by the parliament can become an act only if it receives the assent of the president, right? When such bills is presented to the president for his assent, he has three alternatives. You have to focus on these terms. Has three alternatives under Article 111. You have to remember this article. That is, he can give assent or withhold his assent, or he may return the bill if it is not a money bill. This is an exception where president cannot return the money bill, right? However, the bill passed again by the parliament with or without amendments and again presented to the president must give his assent to the bill. Comment me in the comment section that this provision was added through which amendment act. Okay. Then the Constitution of India does not prescribe any time limit within which the president has to take decision with respect to bill presented to him for his assent. Thus, the President of India can simply keep the bills pending for indefinite period, right? And remember, according to the UPSC PYQ patterns, you have to know what is in India and compare it with US or other constitutions also. You have to do all this. And the objectives of such power is to prevent hasty and ill-considered legislation by the parliament, to prevent a legislation which may be unconstitutional. Exception is that president has no veto power when it comes to constitutional amendment bills. See, here comes two exceptions till now, right? One is money bill, the another one is constitutional amendment bill, right? Then there are three types of vetoes, right? Actually, there are four, but in Indian scenario, there are three. One you can see in US scenario, right? Here in India, that is absolute veto. It refers to the power of the president to withhold his assent to a bill passed by the parliament. The bill then ends and does not become an act. Generally used in the following cases. It is used in private member bills, when the cabinet resigns from before the president could give his assent to the bill. These are the examples. You have to remember these examples because you have to frame such examples in your mains answers, and you will also be asked about such examples in prelims also, right? And for CAPF, the paper 2, they will ask such things. You can quote such things in your paper 2 essays, and for paper 1, you will be asked in the MCQs. just like this question, right? And for the examples here, the 1954 President Dr. Rajendra Prasad withheld assent to PEPSU appropriation bill passed during President's rule in PEPSU, right? In 1991, President R. Venkatraman withheld assent to salary, allowances and pensions of MPs amendment bill passed without the President's prior recommendation. So he has withheld it, right? Then there is another veto, that is suspensive veto. The President uses a suspensive veto when he returns the bill. Remember this. When he returns the bill to Indian Parliament for its reconsideration. If the Parliament resends the bill with or without, you have to remember this key terms, amendment to the President, he has to approve the bill without using any of his veto powers. The repassage of the bill only requires an ordinary majority, whereas there is some difference with respect to USA. In USA, if there is a bill sent back, then there should be a more majority than the earlier. But here, there is less majority than. What is the exception for this? The President cannot exercise his suspensive veto in relation to money bill, which we have discussed above, right? This is similar to that. Then, and for money bill, he must either assent to or withhold assent from money bills. Then for the next veto is the pocket veto. The bill is kept pending by the President for an indefinite period. He neither rejects the bill nor returns the bill. Unlike the American President who has to resend the bill within 10 days, the Indian President has no such time limit, right? Example, in 1986, Zail Singh exercised the pocket veto on India Post Office Amendment Bill, which was criticized for imposing restrictions on press freedom. In 1989 also, the President R. Venkatraman sent it back, but the new government dropped the bill. And when you are reading the state, there is also a certain situation about veto over state bills. The governor empowered to reserve certain types of bill passed by the state legislature for consideration of the President. The President can withhold his assent to such bills not only in the first instance but also in the second instance. You have to remember this exception, right? Such exceptions are mostly asked in UPSC. You have to remember this for sure, right? Then for the second question, under which one among the following articles of the Constitution of India a member of civil service, whether the union or state, seeks protection from unlawful dismissal from service? It is a general knowledge. Most of the aspirants would answer it right. That is answer Article 311, right? Article 311 of the Constitution of India discusses about safeguards of civil servants. Dismissal, removal, reduction in rank of civil servants are discussed in this article. The Article 311 provides protections of it to its servants employed under the union or state, ensuring that the dismissal, removal and reduction in ranks follow certain procedures. It applies to members of civil services to union, all India services and civil services of state or anyone holding a civil post under the union or a state. You have to remember these terms because there are three: union, all India service, civil service of state, right? Then with respect to clause 1, the protection against subordinate authority. A civil servant cannot be dismissed or removed by any authority lower in rank than the authority that appointed him. And who appoints the civil servants in general? President, right? So only President has the power to remove the central government civil servants, right? Dismiss or remove. This ensures that any disciplinary action is handled by appropriate authorities, offering a layer of protection against arbitrary actions by subordinate officials, right? Then the clause 2 of Article 311, inquiry requirement for dismissal, removal and reduction in rank. A civil servant cannot be dismissed, removed or demoted without being informed of the charges against him, being given a reasonable opportunity to defend himself, imposition of penalty. If after the inquiry a penalty is to be imposed, it will be based on evidence from inquiry, based on evidence, right? There is no need to give an additional opportunity for the person to make representations specifically on the proposed penalty, right? There is no need for additional opportunity. Well, for the exceptions to inquiry requirements, if a person has been convicted of a criminal charge, if it is not practicable to hold an inquiry for reasons recorded in writing, if President or Governor believes that the holding of an inquiry is not of the interest of state security. You have to remember these key terms. Then with respect to clause 3, finality of authority's decision. If a question arises on whether an inquiry is reasonable practicable, under clause 2, the decision of the authority empowered to dismiss or remove the person will be final. This gives the authority the discretion to determine whether an inquiry is possible under the circumstances. Here you have to understand the depth of responsibility on an civil servant. Then the third question is, which one among the following reports states that the budget is seen as not as a simple balancing of tax receipts against expenditure, but a sophisticated process in which instruments of taxation and expenditure are used to influence the course of economy? The answer is Plowden Report of Control of Expenditure. The Plowden Report was given in 1961 on the control of public expenditure in UK, emphasized the budget as a tool for economic management, not merely as a book balancing exercise. Budgeting should be seen in broader economic context. See, there will be such questions in UPSC which we doesn't have any knowledge about, right? You can leave this question if you don't know anything about it. Then there should be greater flexibility and coordination in budgeting to align the national economic objectives. This is what he said. And it was turning point in recognizing the role of public expenditure in macroeconomic planning. Hence, the report views budgeting as sophisticated economic tool rather than just an accounting mechanism. Next, these three reports, that is Administrative Reforms Committee report. It has given or focused on reforms in Indian public administration. The Hoover Commission report. ARC is of Indian public administration. Hoover is of USA, concerned with improving US government organization post World War II. Haldane Committee report 1918 UK, related to departmental organization structure, not budgetary philosophy. This is also UK. Plowden is also UK and Haldane is also UK. Right? Then for the next question, which of the following statements is or are correct? Some rights contained in Part 3 of the Constitution of India are enforceable against the state only. Yes, right? Some rights contained in Part 3 of the Constitution of India are enforceable in favor of citizens only. Some rights contained in Part 3 of the Constitution of India are enforceable against both the state and individuals. Right? If you have to remember it easily, for citizens only, when it is mentioned, you have to remember this code 15, 16, 19 and 29. These 4 articles are exclusive for citizens, right? Then here the answer is 3. Mostly in such questions there will be the answer is all, but you have to be careful about terms. They can change it anytime, right? Then for the answer, some rights contained in the Part 3, you can take that as against the state only. you can take the Article 14, and in favor of citizens only, you can take 19, as I have said, 15, 16, 19, and 29, right? Then some rights contained in Part 3 of the Constitution of India are enforceable against both the state and individual. For example, is Article 17, right? State also cannot practice untouchability, and individuals cannot, right? Then for the next question, this is a matching, that is list 1 and list 2. They have given two lists. A. Kothari Mission, Satish Chandra Committee, PC Hota Committee, Professor YK Alag Committee. YK Alag, you will also learn it in poverty estimations, right? Right? Then here they gave inclusion of medical and engineering subjects. This is all with respect to civil services examination, right? See, they are mostly focusing on governance part here. Governance and the polity the constitutional bodies also, right? Then entrance examination of civil service after class 12th, which committee has given, we have to see, and objective methodology for personality assessment, civil services mains examination, written and interview, right? Then we shall see the answer. But the thing is, most probably the UPSC has deleted this question because the answers were wrong, right? The correct answer would be A1432, but there is no options with such options, right? Then we shall see the content, that is Kothari Committee 1966 recommended inclusion of professional subjects like medical and engineering in UPSC. Kothari means, I would remember it as Kotta subjects. That is in Telugu, it is new subjects. That is medical and engineering. Then Satish Chandra Committee 1989. You have to remember these years also, most probably, because they may ask you the chronology. Satish Chandra Committee has came during the downfall of the USSR, looked into the structure of civil services mains and written and interview, right? SC Committee. Then PC Hota Committee suggested reforms like objective assessment in interview and lateral entry. Hota. You can take Hota as quota, right? The lateral entry quota. Then YK Alag Committee proposed National Civil Services Entrance Exam class after class 12, that is in 2000. Specialized training afterwards. These things you have to remember, right? Then, under which one among the following articles of the Constitution of India the seats are reserved for the SC and ST in every municipality? Here the article is 243T. The important articles in are 243D, 243I, 243T, and similarly you have to see the same articles which are for municipalities. These are for panchayats, and you have to see for municipalities too, right? This is also municipality. These two are for panchayats, right? Then we shall see the explanation of this, right? Article 243R, the composition of municipalities. This is important, right? Clause 1 says that all seats in municipalities are to be filled by persons chosen by direct election from the territorial constituencies in municipal area known as wards. This is important. Direct election, territorial constituencies. These three words are important. Clause 2, the legislature of a state may provide for representation in municipality of person with special knowledge or experience in municipal administration. So this is a broad term, right? So there can be any person. And members of House of People, that is MPs and MLAs of state representing the constituencies within the municipal areas, they can be here, right? And members of Council of States and Legislative Councils, Rajya Sabhas, MPs and MLCs also, right? Registered as electors within the municipal area, and chairpersons of committees constituted under Clause 5 of Article 243S. Then the manner of election of chairperson of the municipality. This is also discussed, manner of election, right? Then with the Article 243S, we have completed this R, and then we are going with S. 243S discusses about constitution and composition of wards committees. This is what it is given, right? The clause 5 of Article 243 here. The clause 1, wards committees shall be constituted within territorial area of a municipality having a population of 3 lakhs or more. You have to remember these terms because they may ask you that according to constitution it is 5 lakhs they will give, but you have to remember that this is of 3 lakhs or more. Then the clause 2, the legislature of a state may make provisions regarding the composition and the territorial area of a wards committee and the manner in which seats in the wards committee shall be filled. Legislature of a state make provisions, right? Then clause 3, a member of municipality representing a ward within the territorial area of a wards committee shall be a member of that committee, right? Then for clause 4, the chairperson of wards committee shall be elected by members of wards committee. Then for the Article 243T, reservations of seats are discussed. In clause 1, seats shall be reserved for the SCs and STs in every municipality in proportion to their population in the municipal areas. You have to remember this T, right? And how to remember it? When you read the Lakshmikant, you will see a pattern, that is 243A to P will be for panchayats. Then you have to remember 243Q, there will be municipalities, right? And you can count right from Q, R, S, T. That is 4th article is important. That is 243T is reservations in municipalities. With respect to 243D, that is 4th from A, right? 4th from A is reservations in panchayats. That is similar to this, right? The same 4th one is reservations. You can remember like this. Then for clause 2, not less than 1/3 of the total number of seats reserved for SCs and the STs shall be reserved for women, right? There may be, this is not less than 1/3. That means this is the minimum reservation, right? Minimum. There are some states where they give 60%, even 60% for women, so like Bihar, right? Then clause 3, not less than 1/3 of the total number of seats to be filled by direct election in every municipality shall be reserved for women, right? Then clause 4, the office of chairpersons in the municipalities shall be reserved for scheduled castes and scheduled tribes and women as provided by legislatures of the state. The clause 5, the reservation of seats and offices of chairpersons shall cease to have effect after the period specified in Article 334, right? That is mostly the 5 years period. Clause 6, the legislature of a state may make provisions for reservation of seats in any municipality or offices of chairpersons in favor of backward class citizens, that is OBCs or other one, right? Then for the last article of this question, that is Article 243ZA. elections to municipalities. See, count, you can count from here, that is Q R S T U V W X Y Z 1 2 3 4 5 6 7 8 9 10, right? Then the ZA will come, right? That is 11th article. Similarly, see in panchayats, you have to remember like that only because it is easy to remember such way, right? Then for the clause 1, the superintendent's direction and control of preparation of electoral rolls for and the conduct of all the elections of the municipalities shall be vested in State Election Commission. You have to remember this. There, it has been asked in PYQs of UPSC also, right? Clause 2. The legislature of a state may make provisions regarding all matters relating to or in connection with elections to municipalities, right? Then for the next question, which of the following statements is or are correct? The abolition of Official Secrets Act 1923 was recommended by second ARC, right? And the right to, wait, I forgot to ask you a question. Comment in the comment section below about which constitutional amendment has given reservation for women in legislatures, right? Comment it. Then about this question, the Right to Information Act was enacted in 2005. Most of you might be sure about the second one, but might not be sure about the first one, right? In such 50-50 cases, there is two options, right? That is, you can go with only two or both, right? Then this may be just a trick, but it is in the extreme situation, right? Then the second ARC recommendation, June 2006. The second ARC in June 2006 suggested that the Official Secrets Act of 1923 should be replaced with a chapter in the National Security Act that deals with official secrets, right? This idea was based on 1971 recommendation by the Law Commission. You have to remember about law commissions, right? Work on this, on the static topics, right? To create single comprehensive law on national security. However, in 1980, NSA only focused on preventive measures for public order and security. As a result, the government decided not to repeal the OSA, that is Official Secrets Act, because other national security laws like UAPA, parts of IPC were also not combined into NSA, right? Then Official Secrets Act, it broadly deals with two aspects, that is spying, espionage is spying, right? And covered under section 3. These are covered under section 3. Disclosure of other secret information of government under section 5. If guilty, a person may get 14 years imprisonment. That is what they call in Telugu, right? Deshadrohi, something like that, right? Both the person communicating the information and person receiving the information can be punished under C. You have to remember such typical or specific terms will be asked in UPSC, right? Both person communicating and also receiving, right? Background: OSA has its roots in the British colonial era. The Indian Official Secrets Act 1889. You have to remember this year, that is 4th year of INC formation, was brought in with the objective of muzzling the voice of a large number of newspapers that had come up in several languages and were opposing the British policies. The Act 14 was amended and made more stringent in the form of Indian Official Secrets Act 1904 during the Lord Curzon's. It was extended to all matters of secrecy and confidentiality in governance in the country. Is secret information defined? That is a question, good question, right? The act does not say what a secret document is. It is the government's decision, government discretion to decide what falls under the ambit of a secret. Generally, secret information includes any official code, password, sketch, plan, model, article, note, document, or information. Right? Then Right to Information Act, that is 2005, is a significant legislation in India that empowers citizens to access information under the control of public authorities. The main objective of RTI Act are to promote transparency and accountability. You have to use, it is very much important topic with respect to governance and ethics also. Right? In functioning of the government, empowers citizens by providing them with the right to access information and containing corruption by making the government more accountable to be governed, ensure informed citizenry to keep a necessary vigil on the instruments of governance. The Act mandates timely response to citizen requests for government information and has provisions of the constitution of a Central Information Commission and State Information Commissions to oversee the implementation of the Act, right? And there you have to also refer to the appeal mechanisms also under it. Comment in the comment box about how many levels of appeals are under it, right? Then consider the following statements. The 15th Finance Commission used fiscal effort as a criterion for horizontal devolution, unlike the 14th Finance Commission. You have to remember the chart. Just go to Google and type about 14th and 15th Finance Commission comparison and go to images. You will find many like tables. Just compare them and see, right? Both 14th and 15th Finance Commissions used pre-2011 demographic variables as a criteria for horizontal devolution. Here, only one is right, two is wrong, right? They asked the correct one. The 15th Finance Commission used fiscal effort as criterion for horizontal devolution, right? Fiscal effort, I think it is 2.5%, right? Yeah, it is 2.5%. Horizontal devolution, unlike the 14th. The statement is correct, and the 15th Finance Commission introduced the criterion tax and fiscal efforts with the weightage of 2.5% of the horizontal devolution, which was not used by the 14th. Both the 14th and 15th Finance Commission used pre-2011 demographic data as criterion for horizontal devolution. This statement is incorrect. The 14th used 1971 data, 15th used 2011 data. Okay. Then 9th question. What is the percentage weightage assigned to forest and ecology in the devolution formula given? See, in a single year, they have asked 2 questions on just finance commissions. So see the importance of this finance commissions, right? For sharing union tax revenue with states. We can easily remember this. You will also remember it. Forest and ecology, that is 10%, right? Then for the 15th Finance Commission, horizontal devolution criteria and weightage, I have given you this table, right? You have to mug it up, right? For sure. Income distance 45%. This is a basic criteria, right? And for in that, Haryana would be the top. So Haryana would not get anything under this criteria, right? Then population 2011, 15%. Area 15%. Forest and ecology 10%. Demographic performance, this is important. This is added newly in 15th one. That is 12.5%. Tax effort 2.5%. Right? This tax effort itself is this one which we had discussed. Tax and fiscal efforts, right? Then for the next question, which of the following statements with regard to Anup Barenwal versus Union of India 2023 case is correct? The case was heard by Constitutional Bench. According to the judgment, the grounds for removal of election commissioners shall be the same as CJI. This is an important case which was in current news, current affairs, right? That is, only one is correct, two is wrong. And we shall see the content of Anup Baranwal and Union of India case, right? The petitioners in this argued election commissioners should have the same protection or from removal as CEC, right? That is, there will be a CEC and 3 ECs, right? So they are just saying these two should have equal powers. Article 324(5) states that CEC can only be removed in the same way as Supreme Court judge, and their service conditions cannot be changed in their disadvantage. Other election commissioners can only be removed if CEC recommends it. This is the only provision mentioned, right? But they are arguing that similar to CEC, ECs are of similar rank, right? So they should also be given the same status as Supreme Court judge, right? In the removal, right? The court disagreed with the petitioners. It explained that if an election commissioner had the same protection, they would be shielded from removal unless impeached like Supreme Court judges, and CEC would also need to recommend their removal. The court left it to the parliament to decide whether to extend this protection to ensure the independence of election commissioners, right? Anup Baranwal versus this we have discussed, right? Case challenged, this we have already discussed, and the judgment also we have discussed, right? Yeah, this is a recent current affair, that is 2023, right? Then for the next question and the last question of this video, the National Council of Science Museums, NCSM, which is developing science centers, museums, innovation hubs in India, works under which ministry? It is about science museums, right? But when you listen the terms museums, you have to remember it is under culture, right? And when you listen to culture, you have to remember the FDs. Comment me in the comment box which FD talks about protection or preservation of heritage site, right? Then we shall see about National Council of Science Museum. National Council of Science Museums is an autonomous society, right, under the Ministry of Culture, Government of India, established in 1978. You have to remember this 1978, that is 44th Amendment Act year, right? NCSM administers 26 science centers and museums across India. Key national level science centers are: one is in Kolkata, the Science City. Another one is also in Kolkata, the Birla IT Museum, right? And Nehru Science Center is in Mumbai, and Visvesvaraya IT Museum is in Bangalore. Then the National Science Center is in Delhi, and National Science Center in Guwahati also, right? Except for Science City, that is in Kolkata, all centers have regional and sub-regional science centers called satellite units, right? Formation and expansion. In the early 1970s, a task force from the Union Planning Commission recommended setting up of national and regional and district level science centers and museums. Task force from Union Planning Commission. You have to remember this. And NCSM, headquartered in Kolkata, has a network of 26. We have discussed about it, right? Here it is, the 26. Additional roles and collaboration. Scheme for promotion of culture of science. NCSM serves as an implementation agency under the Ministry of Culture, helping develop science centers and museums for different Indian states and UTs. NCSM has worked with organizations like ONGC, BE, like ICAR, and collaborated internationally with museums and science centers, including the Rajiv Gandhi Science Center in Mauritius and International Buddhist Museum in Sri Lanka. The science communication and international exhibitions. The NCSM promotes science through mobile science exhibitions, lectures and demonstrations, training and workshops, publications. It has also organized expeditions in countries such as USA, USSR, France, China, Bangladesh, South Africa, Malaysia, and others. Right? So this is it. These are the questions which has been asked in 2024 of CAPF AC. That is Assistant Commandant, right? So in the next video, I shall come up with the 2023 Polity PYQs of CAPF, right? Till then, stay tuned. Jai Hind. कृतज्ञाहम्